So if you don't want to take down every single thing that Randy says, you don't have to, because we'll make this recording available to you. This will be sent out to everyone who registered for this session by the end of business today. We'll also send you, with Randy's permission, a PDF copy of his slides. So that will help you not have to write every single thing down today. Randy's going to go ahead and take your questions as we go today. So feel free to drop your questions in the chat, and he will periodically at the right time kind of stop and take those questions and answer as he goes. So feel free, as questions come to you, to just type those into the chat there, and we'll take those as we go. For those of you that are joining us this morning and you hold a credential with the National Apartment Association Education Institute, like your certified apartment manager, your CAPS, something like that, today's session is good for one continuing education credit that will be put into your member compass for WMFHA members right online as soon as they verify your attendance. So you can go at any time and download all of your CECs out of your member compass. So no need to have anything emailed to you after the fact today. As long as you stay on the session for its duration, you will earn your continuing education credit, and it will be in your member compass. All right, with that, I have no more announcements. I'm going to hand things over to Randy, turn off my camera, but I'll still be here supporting in the background. But Randy, Redford, thank you so much for being such a great partner to our industry, for sure, and also to WMFHA all of these years. And thank you for spending some time with us today.
Thank you. So as I'm going to start going through this, before I do, when I screen share, I generally turn my camera off because I tend to talk with my hands and I forget that the camera is recording me. So it may look like I'm having a seizure of some kind. So I am going to click the camera off and we're going to start in on this. As Sloan said, if you have any questions as I go along, just type them in the chat box and we will answer them rather than keep them until the very end. Okay. Why is my, yes, any person can make a complaint. Okay. All right. I am up with screen sharing now. So we are going to cover the complaint process. So if anybody has ever been involved in a discrimination complaint, you will be familiar with some of this. It changes a little bit depending on which agency is doing the investigation. And investigations can be really intense or they can be very short-circuited depending on the investigator that you get and whether the investigator feels that there is any basis for the complaint. I currently have about 60 open discrimination complaints that I'm working on. So I go through a lot of these. I do somewhere around 150 a year, and numbers are going up. So there are a lot of discrimination complaints being filed right now. In terms of making a complaint, it is very easy to do. The person can go online, either with HUD or with one of the state or city agencies and fill out an online form. And as soon as they hit send, they've effectively filed that complaint. They will get a copy of the complaint back for them to sign. And the day they sign the complaint, it will be an effective and active complaint. Any allegations that they make in the complaint are made under penalty of perjury. So I use that in a lot of instances in my defense of these to claim that they are lying under oath effectively. There are no costs associated with a discrimination complaint. So with a lawsuit, when you file a lawsuit, you have to pay the filing fee and the service fees. There are no such costs like that with a discrimination complaint. So that's why you will see a lot more discrimination complaints than you will discrimination lawsuits. When you file a complaint, you can file it with HUD directly, and HUD will either be the investigative agency for their own complaint, or you can file it with a state or local agency, such as the Washington State Human Rights Commission. Any complaint filed for a property in the city of Seattle is generally investigated by the Seattle Office of Civil Rights. But be aware, if the person files the complaint with HUD, HUD used to assign the investigation to SOCR, the Seattle Office of Civil Rights. That agency has now lost their contract with HUD. So HUD either does the investigations themselves or assigns it to the Human Rights Commission. In the past, when HUD did their own investigations, the cases would draw out for a tremendously long amount of time. As I go through this, you will see that these are all supposed to be resolved in 100 days from the day that the complaint is signed. I had cases where HUD was the investigative agency, and again, this was 3 or 4 years ago, but I had those cases which had been pending for 7 or 8 years. So they just sit on somebody's desk and they never really get investigated, or they just stop in the middle of it. The recent ones that I've had where HUD has been the investigation, they go very quickly. They're done in 2, maybe 3 months. So those are great. And the HUD investigators are getting much better. They used to be very pro-tenant. Now they are much more reasonable to landlords. Most of the Washington State Human Rights Commission investigators are pretty good. They are neutral, so you will get a fair investigation from them. The Seattle Office of Civil Rights investigators, however, for the most part, are very pro-tenant. I have had a few cases recently been determined in the landlord's favor, so that's a good surprise because it had been several years since I had a finding in a landlord's favor from SOCR. King County Office of Civil Rights and Tacoma Civil Rights Office are pretty much out of the business. I haven't had a complaint assigned to them or investigated by them in 5 or 6 years. So it's generally HUD, Human Rights Commission, or the Seattle Office of Civil Rights. When they file a complaint, statute of limitations is 1 year from the alleged discriminatory act. So what you do is you look at the date that the complaint was signed by the charging party, and you go back 1 year. Anything that is within that 1 year is considered fair grounds to do the investigation on. If it is beyond 1 year, then my argument is it is outside the statute of limitations and the investigation cannot continue on those claims outside of 1 year. There is a loophole on that 1 year statute of limitations, and this loophole comes from mainly employment discrimination cases. And that is if the charging party can make a reasonable claim of a pattern of discrimination, then the law says that they can go back further than 1 year because of that ongoing pattern of discrimination. The issue that you have to look at there is it truly a pattern, or is it 2, 3, 4 disparate events which they are trying to claim as a pattern? There is a tenant advocacy group out there called the Fair Housing Center of Washington that files some of these complaints. And what they used to do, they don't do it so much anymore, is they would file complaints on visits that they made to properties. And they would do one visit 3 years ago. They would do another visit 2 years ago. They do another visit 11 months ago. and then they would file their complaint, and they would allege all of those actions as a pattern of discrimination. And eventually the investigators started calling them on it and saying, that's not a pattern, that's 3 disparate events. So we're not going to investigate anything beyond the last one. So that's kind of gone away. But be on the lookout for things like that. Standard of review in a discrimination complaint is preponderance of the evidence. The charging party, who is the person who filed the complaint, has the burden of proof. So they need to prove by 50.1% of the evidence supporting their claim that that these actions actually occurred. If they can't meet that preponderance of the evidence standard, then the discrimination complaint fails and there's a finding in favor of the respondents. The parties are the charging party or complainant, which is the person who filed the complaint, and the respondents. So if you think of a regular lawsuit, the charging party is analogous to the plaintiff, the person who files the lawsuit. The respondents are all of the defendants. And in a discrimination complaint, the respondents will be everybody in the chain of command who was involved with the alleged discrimination. So if the discrimination complaint is the leasing agent said something to me and I think it was based on discrimination, the respondents will be the leasing agent, the on-site manager, the area manager, the management company, and the owner of the property. What HUD will tell you is they want everybody involved in the chain of decision-making to be aware of the discrimination and to be responsible for the discrimination. As we go along through this, you will find that I am a little bit jaded because I've seen so many of these complaints. And I think the reason everybody is named is because HUD is looking for the wealthiest entity or the entity with the deepest pockets. So if there is a settlement, they can ensure that a higher settlement amount is able to be paid. But you can be named personally in these complaints. So be careful of what you do. And in fact, I have had a couple of complaints where I represent the management company, and the management company has admitted in their answer that an employee did discriminate, but their defense was that we sent the employees to all of these fair housing classes. They were told in writing that they cannot discriminate. We taught them what not to do. And so if this person did discriminate, which they didn't defend that they did not, they didn't claim that they did not discriminate, but their defense was, we should not be held responsible because she acted so far beyond the pale of what her training was that we cannot, essentially watch her 24/7. And so you should hold her responsible, but not us. That complaint is still pending. It's been pending for about 4 years now. And I am kind of a proponent of don't poke the bear. So if this complaint is just going to sit on somebody's desk for 4 years, I'm not going to hassle the investigator and say, I want a finding one way or another. I'm just as content to let it sit there. Because as long as it sits there, there's no finding of discrimination. So, elements of the investigation. This is where it starts getting interesting. So the charging party fills out the complaint, signs it, and then that starts the process. You will receive notice by certified mail. There, it comes in, or the difference comes in as to who got the complaint initially. If it was filed by HUD, and HUD designates itself as the investigative agency, you will get one notice of the complaint. Every respondent will get a separate notice, but they don't necessarily mail out things to different addresses. So if it's the leasing agent, the manager, the area manager, and the management company, they may all get a copy of the complaint, but mailed to the property because they don't have addresses for everybody else. So be on the lookout for things like that. If the complaint is filed with HUD, but HUD designates the Human Rights Commission as the investigative agency, you will get the first notice of the complaint from HUD. And in that letter, it will tell you this other agency has been designated to do the investigation. And in 10 days to 3 weeks after you get that first letter, you will get another certified letter from the Human Rights Commission telling you they've been named as the investigator and that they will start their investigation at this point. That letter from the investigative agency will also tell you who the assigned investigator is. So you want to know that because that is the person that you will contact from that point on with anything related to the investigation. So that's always good to know. And for me, because I do so many of these, it is good to know who the investigator is because I will have a better idea of how they are going to treat this investigation. The complaint contains a housing discrimination complaint or a housing charge. It's the same basic document, but they call it different things and it looks differently. So Seattle Office of Civil Rights calls it a housing charge, and it is much shorter than the housing discrimination complaint, which is used by HUD and the Human Rights Commission. The housing charge may only be 2 paragraphs long by SOCR. The Human Rights Commission uses a much better form. So you're going to want to look at that form whenever you get named as a respondent. This is what going through a standard housing discrimination complaint, it has various sections, and you want to look at all those sections. Section 1, who filed the complaint? It's good to know who the person who filed the complaint is, because if it's a tenant, that will give you a lot of indications as to what your defense is going to be, because with an existing tenant, you will have a history with that person. Did they file all kinds of maintenance requests? Have they filed discriminations in the past? Have they been just a problem tenant? Things like that are always good to know in these discriminations because they'll help you prepare a defense. Section 2, did the person file just on their behalf, or are they filing for somebody else? The person who files the complaint doesn't need to name themselves. So a parent can file a complaint solely on behalf of their children, or something like that. So we want to know everybody who is named in this complaint, because we have to address all of them. If it's parents and children, there may be certain protected classes that only apply to the children. So we want to know who everybody was. Also, section 2 is if there's a lawyer involved or an agency like the Fair Housing Center of Seattle. That's good to know, because if it's a lawyer, then I have to deal with the lawyer. Most of these, I would say 95% of them are not filed by lawyers. They are filed either by the person for themselves, or they're filed by the Fair Housing Center of Washington. If it is the Fair Housing Center of Washington, I know it's going to be harder to settle a complaint because Fair Housing Center tends to push unreasonable settlements. So I want to know that when I go into this. Section number 4 is the legal basis for the complaint. That is, what the person is saying. Is it a failure to rent case? Is it a failure to accommodate a disability case? Those are the claims which we have to address in our response. Section number 5 is what protected classes are involved. We also have to know those because our answer has to look at all of the allegations of the discrimination and evaluate them under all of those protected classes. So my record right now is I had a single discrimination complaint in which the person filed just on behalf of herself, but she made something like 22 separate allegations of discrimination, and she listed 12 or 13 protected classes. So for all of those 20-some allegations of discrimination, we needed to evaluate them under all those protected classes. So my answer in that case was close to 300 pages long, just because we had to look at everything under all the protected classes. So we need to know that to know why they're claiming that they were discriminated. Section 6 only comes up if we think that the entity doing the investigation doesn't have jurisdiction. So if the person is living in Idaho and they file it with HUD, and HUD assigns the Washington State Human Rights Commission to do the investigation, Human Rights Commission for Washington State has no jurisdiction in Idaho, so they can't do that investigation. I've actually had a discrimination complaint dismissed based on the fact that the assigned agency did not have jurisdiction over the address where the discrimination occurred. Section number 7 is who are all the named respondents. So we want to see who we have to answer from. Normally, when I answer a discrimination complaint, I answer on behalf of the owner, the management company, and any current employees of the management company. If in the investigation, the management company terminates an employee, they may ask me to stop representing that employee, depending on the reason for the termination. The downside of not representing everybody in a discrimination complaint is I don't get to participate in the interviews for respondents who are not my clients. So if there is a management company and 2 individuals named, one of them who is an employee, one of them is a former employee, we don't have any control over what that former employee is going to say. So sometimes what happens is the parties start to throw the other parties under the bus. So I generally take the proposition that I'm representing everybody until one of my clients tells me, no, you don't have permission to represent this entity. And then I have to disclose that to the investigator, and the investigator deals with them on their own. Section 8 of the housing charge is the most important because it is the guts of the discrimination complaint. It is the charging party saying, all of this happened, and here's why I think all of that it was discrimination against me. So those are where we're going to have to look for, are they alleging that we didn't do maintenance on time? Are they alleging that we treated them differently because of their race? And how did we treat them differently? Some complaints are more detailed than others. And for some of the complaints, I have gone back to the investigator, and in my response, I have said they're making an allegation. They're not giving us any facts of the allegation. And so therefore we can't form a defense. So unless they're going to give us the facts, we can't dispute this. And you, the investigator, cannot find discrimination without giving us an opportunity to refute those facts. So at that point, we will either get an amended complaint or the investigator will tell us they are no longer relying on those facts. So we want to, those are the main issues that we want to look at is under Section 8. Section number 9, the only thing that we're looking for is that last alleged date of discrimination. Does it fall outside the 1-year statute of limitations? If it does, because that is the most recent allegation of discrimination, if it's outside the 1-year statute, then everything else is outside the 1-year statute, and we can try to get the discrimination complaint dismissed based on being outside the statute of limitations. Okay. You can either represent yourself or you can have an attorney or other person representing you, just as I said before. When we get a discrimination complaint, my first action is to send a letter to the investigative agency saying I am representing the respondents. The reason I do that is because they know, at least while I'm representing them, that they're going to get an answer. You're not ignoring this. And so in the initial discrimination complaint, you will find something that says you now have 10 days to give us the answers or give us your defense to all these allegations. As soon as I appear, that 10-day window basically closes. And it is then up to me to deal with the investigator to say, I'm working on it. My client's on vacation. I will get it to you as soon as I can. And I generally have no problem getting an investigator to give me a continuance on that 10 days. I have one that I'm working on now that I've had it for 2.5 months. And I haven't filed a response yet. But the investigator has never even communicated with me about asking for a response, because at this point, all of the investigators for the Human Rights Commission are so swamped with these cases that I may file a response to a discrimination complaint, and it may be 6 months before I initially hear back from the investigator. So that is not uncommon at all in these cases. But we want to be able to say to the investigator, we are working on this, because the investigator, if you don't tell the investigator that and you don't appear in that 10 days, technically they can find discrimination against you. So that's why I immediately communicate with them and let them know I'm involved. Oh, I skipped part of that. After we send in our investigation, the next thing is usually either interviews, and the interviews are almost always done by phone, or the investigator will ask for additional documents. Some of the times they ask for the documents first and then do the interviews, or they'll do the interviews and then ask for additional documents. They can do both. It's kind of a back and forth process from then on. They will interview the charging party and they will interview the respondents. The frustrating thing with a discrimination complaint, unlike a lawsuit, is that we don't get to see any of their documents and they don't get to see any of our documents. The only person that gets to see everything is the investigator. With a lawsuit, I get to see all of the evidence that the plaintiff is going to use, and the plaintiff gets to see all my evidence. But we don't get to do that with discrimination complaints. So the charging party can make allegations and say, I have a text message that I got. And I said, well, great, send me the text message. And the investigator does not have to do that, because I don't get to see all that information until the investigation is complete. Then it becomes a public record and I can see everything, but that doesn't do me any good. So A lot of the investigators, because I work with them so often, they will either give me the information or they will hint at it so broadly that I know what it is, just so that I can perform it. I can give them a defense to it. But if you're new at this, you may not get that option. So just be aware of that. Okay, 4 elements. These come from a federal lawsuit by the US Supreme Court, McDonnell Douglas versus Green. Again, the charging party has the main burden of proof on all 4 elements. If they can't prove all of those elements, then the complaint fails and you get a finding of no discrimination. With SOCR, they take the position that simply by filing the complaint, the charging party has met all 4 of its elements. So ultimately, you are going into an investigation done by the city of Seattle being guilty until you can prove yourself innocent. It's completely contrary to federal law, but SOCR, and if pushed at it, SOCR will say, oh no, we don't ever do that. But I've been told on numerous occasions that's how they get trained. So I just go into it assuming that they think you're guilty and we have to prove ourselves innocent. All right, element number 1, I'm going to go through all 4 elements. Some of these are more useful than others, but these are the elements that the charging party has to prove. And these are also the elements that I use for my defense. So these are the most important part of a discrimination investigation and my defense of it. So element number 1, charging party has standing to file a complaint as a person of a protected class or on behalf of a person of a protected class. We almost never contest this because there are so many protected classes out there. A person can fit themselves into one of them. So depending on, I've probably used this element 5 times out of all the discrimination complaints that I've investigated and provided defenses to. So it just does not come up that often. Element number 2 comes up all the time. That is, charging party attempted in good faith to meet the qualifications and conditions for tenancy set out by the landlord, and they met the minimum qualifications for the rental. This comes up in something called a failure to rent case. A failure to rent discrimination case is a case where the landlord either didn't rent to somebody or the landlord terminated an existing tenant. Those are both failure to rent cases, even though in the second one, you did in fact rent to them, but you're moving to terminate them. So what we have to try to prove is that the reason we either didn't rent to them or that we terminated them was because they did not meet the qualifications for the tenancy. On a lot of these, I will try to give you examples from real cases that I have done. And the example that I always give in this case is we had a termination of an African-American tenant in Everett. She was not Section 8, she was not tax credit, and this was 7 or 8 years ago. So we could terminate her without cause. That was what the law was at that time. So the management company gave her a 20-day notice to terminate at the end of her initial lease. And she filed a discrimination complaint saying, the only reason I got this termination notice is because of my African-American status. So that's what we had to work on the defense. So we looked at her tenant file, and she had lived there for 12 months. And at the end of that 12-month initial lease, we terminated her. In that first 12 months of her tenancy, the management gave her 11 pay or vacate notices, 22 or 23 10-day compliance notices. The police were at her apartment 10 or 11 times, and there were 4 people arrested out of her apartment. So our argument was she did not, with that kind of behavior, she cannot claim that she attempted in good faith to meet the qualifications of tenancy. The qualifications are you pay your rent on time and you comply with the rules. So our action was based on her failing to meet the requirements for tenancy, as opposed to anything having to do with her race. So based on that, the investigator came back and said, no, you didn't discriminate. She failed to meet element number 2. And because she failed to meet that, her discrimination complaint fails. Element number 3, again, this doesn't come up that often, and that is the respondents had knowledge of the charging party's disability or membership in a protected class prior to the allegation of discrimination. This comes up sometimes depending on what the protected class that the person is basing the discrimination on. One of the protected classes out there is called ancestry. Ancestry is where your parents or grandparents were born. So if you may have an ancestry of an Asian ancestry or an Eastern European ancestry. There's also a protected class out there called national origin. That is where you were born. So the landlord, both of those are protected classes, and the landlord is not able to discriminate against you based on either of those protected classes. But if the allegation is based on ancestry, the tenant then has to prove that at the time we engaged in whatever conduct they claim was discrimination, we knew what their ancestry was. So they have to prove we knew where their parents or grandparents were born. So that's why this doesn't come up that often. It almost never comes up in a race-based discrimination because race is fairly obvious looking at the person. It comes up occasionally in race-based cases when we're dealing with not existing tenants, but applicants, and the entire application process occurred online. We've never talked to the defendant or the charging party. We've never met the charging party. We've never spoken to them on the phone. So what agencies are now starting to do is base these claims on things like racial sounding names or racial sounding voices, which I mean, racial sounding names, possibly. And it's always usually, you had an issue with John Doe, Bill Smith, and you also had an issue with Muhammad Abdullah, and you treated Muhammad Abdullah different than you did Bill Smith. And the allegation is you did it based on the fact that Muhammad Abdullah had a racial or a protected class sounding name. The racial sounding voices are a little bit harder because really all the landlord has to do is get up there and say, I either never talked to this person or I was unable to tell from their voice what their race was. And then it's a judgment call on the investigator about whether it is reasonable that somebody could determine somebody's race solely from their voice. These are relatively new, but they are coming into play. They mainly come in with testers. So I'll go through testers in a little bit, but that's how the racial sounding voices and names really come up. Element number 3 is another one that comes up all the time, and that is the respondents offered more favorable terms of rental to persons not of this protected class. So if the allegation is management terminated my tenancy because of my race, what we can show is we also terminated people that were not minority members. And so we're treating minority members the same as we're treating Caucasians, or we're treating disabled people the same as we're treating non-disabled people. We have a set of rules. Everybody has to play by the same rules. And if you violate those rules, there are consequences. It has nothing to do with your race or your disability or any other protected class. It's simply because you violated the rules. Excuse me. What we use to make this claim is what are called comparator notices. So if the allegation is a 20-day notice, what we're looking for is 20-day notices that we serve to somebody not of that protected class. Or if it's a 10-day notice, they gave me a 10-day notice because of an odor issue, and the odor issue is curry, and I'm of Indian descent. So that is a discrimination against me because I cook with curry. So they're discriminating against me. They gave me a 10-day notice because of the odor of the curry. What we're able to do is say, no, we gave them a 10-day notice because they are creating an odor that is impacting other people. And all we have to prove is that we've given similar notices to other non-Indians. And we can use other types of odor notices. So in odor cases, I almost always use smoking notices for comparators. We don't care what the odor is. It's just the fact that you created an odor in your unit and it impacted other residents. So your odor happens to be curry. This other unit, who we also gave a 10-day notice to, or a 20-day notice, was an odor of smoke from cigarette smoke. It's the same type of thing. So if we can find comparator notices, we are much better off, and we go a long way toward defeating a claim of discrimination. Once the investigator determines that the charging party has met all 4 of their initial showings, the burden shifts to the landlord to prove that we had legitimate, non-discriminatory reasons why we took that action or didn't take that action, depending on what the allegations are. That's where the comparator notices come in. And element number 2 comes in. Was the tenant in violation of the rules? So were we able to say, we gave you these notices, or we're terminating you because you were in violation of the rules? That is our legitimate, non-discriminatory reason for the actions that we took. If we meet that shifting burden, then the burden shifts back to the charging party to show that our legitimate, non-discriminatory reasons are a sham or a pretext just so we can discriminate. I can tell you, I have never actually done a discrimination complaint where we've gotten to part 3, where the investigator has said, I think your claims of why you did this are really made up by you just so that you could discriminate against somebody. And if I ever have an investigator tell me that, that means I need to settle this case because they are going to find against my client. So at that point, it's a trigger to me to try to settle. There are 3 possible outcomes in a discrimination investigation. 1, the parties settle either inside the discrimination complaint or outside, called a private settlement. There is a no cause finding. That is, the investigator finds that the charging party did not prove all 4 of the elements. And so they're finding that discrimination did not occur. That is the most common finding, especially with the Human Rights Commission. Settlements are probably 20% of the cases. Findings of no cause are about 70%, and a finding of cause is about 10%. But Most of the time, they don't get to a finding of cause because once there is a finding of cause, we then try to settle it. A finding of cause is simply the investigator saying, I think you discriminated. So we're trying to avoid that at all costs, because once we get to that, these cases get much, much more complicated and much, much more expensive. Settlements. The rule of thumb is if you're going to settle a case, settle it early. The earlier you can settle a case in an investigation, the better off you are and the less expensive that's going to be. So a lot of times I'll look at a claim and I'll talk to my client and they say, well, yeah, sort of that stuff did happen. And I'll say, well, rather than spending the money on the investigation, give me a couple of things that I can talk to the investigator about that may be in our favor. And then let's start asking about settlement options, because you don't want to have to pay for the investigation and then get all the way through the investigation and then decide you want to settle, because that's more expensive. One, because you're paying for the investigation and then you're paying for whatever the settlement terms are. And if we can do it early, then you save some of that money. There is the investigator's only role is passing offers back and forth. And with some of the investigators, it becomes comical, at least to me, because I will get an email from an investigator that always starts out, as you know, part of my required duties in this investigation is to make the other side aware of a settlement offer. Whenever the email starts like that, I know the settlement offer is going to be ridiculous. And settlement offers can be anything the parties can agree on. I've had cases settle with simply a change in policy. The charging party says, I want them to clarify their reasonable accommodations policy so I know what to expect the next time and nobody else has to go through this. Most management companies are very happy to settle for something like this, because if we can do that early, they get rid of this complaint without really any costs or very little costs. I've also had people make settlement offers of $9 trillion. I've had one settlement offer where they wanted the management company to make donations to the 16 entities out there that the charging party named. They wanted $500,000 a year to all of these 16 agencies in the charging party's name so that we would penalize, yada, yada, yada. And, my answer is always, I'm pretty sure they're going to reject this settlement. So go ahead, continue on with your investigation, but I will confirm with my client. When you get a settlement offer, it's always a good idea to make a counteroffer. And you may get a settlement offer of $100,000. And depending on where we are in the process and what we think of their claims, we may make a counteroffer of $500. And in fact, I've had initial cases where it's $50,000 to settle, and we make a counteroffer of $500, and the charging party takes it. Because at some point, the investigator, even though they're not really supposed to, they may say to the charging party, you've really got nothing here. And you should try to settle this if you're going to get anything out of it. So they will take a settlement like that. I also have investigators telling me, you really need to settle this because I'm leaning toward finding discrimination. So at that point, I know we have to make our settlement offer higher. Then it just becomes a normal settlement. It is back and forth. You can do so there are some mandatory terms. There's fair housing training and always a mandatory term. It's now a 90-minute video that you have to watch, and you just certify to them that you watched it. That settles that. And then a photograph or proof that you're displaying a fair housing poster in the management office. Those are two mandatory terms in every settlement. If you do a settlement in the investigation, there is no finding of discrimination. In fact, the settlement specifically says that they did not find discrimination if you do it early enough. If you do the settlement after there's been a finding of discrimination, then they will say they found discrimination, but thereafter the parties reached a settlement. So again, do it early. Payment is whatever the parties agree on. Most of the time it's a couple $1,000. But you kind of weigh that with what are you going to pay to go all the way through the investigation. So can you offset one against the other? And a lot of times I can look at these and I can say, okay, I think based on what I'm seeing here, I think you've got an issue on some of these. So maybe we want to look at settlements. And what I generally ask clients to do is just starting out, tell me the maximum amount that I have to settle this, and they may say $5,000. I'll make an initial settlement offer of $500 or $1,000 and see if they take it. I'm not going to jump in right away and offer the $5,000 because I want some negotiating room. And the lower that I make my offer, the more it tells the investigator, we don't think there's anything here, but we're offering a nuisance settlement. Rather than pay to go all the way through the investigation, we're going to pay this small amount just to make the thing go away. And you can sometimes get those through. Other times you go back and forth, and depending on what terms you want, you may be able to do the settlement in the investigation. If you want terms that HUD cannot agree to, then you have to do a private settlement. And a private settlement is a settlement between the parties without involving the investigator. You can kind of use them to pass them back and forth, but part of the terms of the settlement is that when we meet all of our obligations, we being the landlord, the tenant will withdraw this complaint and will be prohibited from filing any similar complaints. That's a private settlement. And those terms tend to be things like if there's a lawsuit and a discrimination complaint, and I have 3 or 4 of those right now, you can do a global settlement of both the lawsuit and the discrimination complaint in one document. So the other types of private settlements that I see sometimes is when the landlord wants to make a term in the settlement that the tenant vacate, or the tenant is no longer eligible to live in any property managed by any of the respondents. So those generally the costs go up because the charging parties will say, well, wait a minute, this is a big management company. They manage a lot of properties. And if you're cutting out my ability to move into any of those properties, you're going to have to pay me more for that. So then it becomes, is the landlord willing to increase the settlement amount to get the terms that they want, which normally could not be allowed? And you may have to do a private settlement for that. A no cause finding, like I said, is the finding that the charging party did not meet all 4 of its burdens. So the landlord effectively wins. With a finding of no cause, the tenants have a right to appeal. So, but appeals are rare. And the way an appeal happens is we will get notice that the investigator found on behalf of the landlord found no cause and why. And along with it is always a notice telling the charging party how they can appeal. If they file an appeal, they have to say what they think the investigator missed or didn't adequately investigate. And appeals are not taken automatically. The board will go back and look at the investigation, look at all the information and say, do we think that this was adequately investigated and all of the allegations were investigated? And if they find that, they will reject the appeal right off the bat. If they find that there's an issue, they can limit the appeal. We're going to grant the appeal only on this small issue. All of the rest of the grounds for appeal are denied. And then what they will do is conduct a new investigation on just that limited issue. With a finding of no cause, it does not preclude a landlord from, or excuse me, not a landlord, a tenant from going into court and filing their own lawsuit. A settlement will preclude that, and that's one reason for doing a settlement. However, a no cause finding is not a bar to a lawsuit based on the same allegations. The other issue is, while the discrimination investigation is going on, the statute of limitations for filing that lawsuit is what's called tolled, which means if it is a 2-year statute of limitation to file the lawsuit, if that investigation takes up 1.5 years of that 2-year period, during that 18 months, that 2-year statute of limitations is not running. That is the only downside to letting an investigation go beyond the time of the 100 days. But in all of my investigations, I've only had 3 cases where a tenant actually went out, even though there was a no cause finding, and filed their own lawsuit. So they're very, very rare. And the reason they are is because lawsuits filed by tenants, lawsuits as opposed to complaints, are really complicated and they're really expensive. The last federal discrimination lawsuit that I defended a landlord on, the landlord eventually prevailed, but my attorney's fees were $78,000. So these can be very expensive to litigate in court, whereas in a discrimination complaint, they're much cheaper to do. So if you're going to get a discrimination, your fingers are crossed for a complaint versus a lawsuit. They're quicker, they're easier, they're cheaper. But most people just, they file these things sort of in a fit of rage, and they kind of work out their rage through the investigation, and having a third party tell them, you don't really have anything here. A lot of them will listen to that and say, well, I'm just going to get told the same thing if I file a lawsuit, and filing a lawsuit is going to cost me $500. So do I want to spend the $500 to file a lawsuit when I've already been told there's nothing here? With a finding of cause, and that is a finding of discrimination, usually the investigator will try again to settle the case. But for a landlord, those settlements are much more expensive. In my case, I did a discrimination complaint only at the very end. A tenant moved out of a unit in the middle of a lease. He was 21 or 22 years old, and he had a traumatic brain injury. He was a veteran. He served in Afghanistan and Iraq. He came back with a TBI, and he lived by himself for a while, and eventually his disability just made it impossible for him to continue living by himself. So his parents came and contacted the manager and said, we just, he has to go into assisted living. We want to break the lease as a reasonable accommodation. The manager said, absolutely, we will let him break the lease. We won't charge the lease break fee. We'll only hold him rent responsible up through the day that he vacates. He'll have to pay the cleaning and damages charges for any damage that he did in the unit, but that's it. That is exactly the right answer. That is exactly what the landlord should have said. And that is exactly what the landlord did say. That is exactly opposite of what the landlord did. When the tenant moved out, they charged all the rest of the rent for the lease. They charged a lease break fee. They forfeited the deposit. They charged all the cleaning and damages. And then they sent him to collection for like $8,000. It's exactly the opposite of what they told the parents they were going to do. So the parents filed a discrimination complaint on behalf of the kid. The management company represented themselves in the discrimination, and kind of no surprise, there was an option to settle it for a very small amount of money, less than $500. But they rejected that offer on the grounds that they said we didn't do anything wrong. And so there was a finding of discrimination. Clearly, the landlord failed to reasonably accommodate this guy with a TBI. So the investigator told them, we're going to find discrimination against you. And when there is a finding of discrimination, if the case doesn't settle, the investigator then refers it on to the attorney general to file a lawsuit. So you and all the other respondents get sued not by the tenant, but you get sued by the state of Washington. So you've got a really hard case to do. And there are assistant attorney generals who do nothing but discrimination lawsuits. At least here in Washington, they love to do discrimination lawsuits, and they're very expensive. Average attorney's fees in a discrimination lawsuit are $100,000. So in my case, after there was a finding of discrimination, the landlord came and contacted me and said, here's what's going on. We need you to fix this. And I was telling him, I can't fix this. We're 9/10 of the way through this, and everything you did after the tenant vacated was wrong. So there's no way I can fix this. So we ended up doing a mediation for the settlement. But by that time, the charging party had already been told that the landlord discriminated against them and how they discriminated. And that if this case wasn't settled, that there would be a referral to the attorney general to sue the landlord on behalf of this disabled kid. So you can imagine at that point, the parents of the disabled kid, one, are really angry because they've had to go through this whole process. And two, they pretty much have the landlord over a barrel, because the landlord either reaches a settlement or gets sued by Washington, and it becomes very expensive. So we did ultimately settle the lawsuit in the mediation, but the settlement was $27,000. So they had a chance to settle for less than 500 early. They ended up settling for 27,000. So really take to heart, if you're going to settle early, and do not let these get to a finding of discrimination. All right, takeaways. Best practices for defeating a discrimination complaint. Number one, 95% of discrimination complaints can be defeated if you have good written records. A lot of discrimination complaints are, so-and-so said this to me. And if you have written records that show you didn't say that, your written records are going to trump their claim that you did. So anytime a tenant says something to you like, why are you treating me this way? I don't think this is fair. You're not treating other people this way, or mentions discrimination or race. You're doing this because I'm Black or I'm disabled or something like that. That should set off a bell. And from that point on, anything having to do with that issue, you need to tell the tenant in writing or email, you've made some complaints about the way that we are treating you with respect to this issue. So therefore, we believe that we need a record of everything that is said related to this issue. So from now on, all of our responses to you, and when we say all of your communications with us about this issue, need to be in writing or email. Your reason for doing that is making a written record so that you are able to say later on, the tenant says I said this to her. I didn't. In fact, I have an email that says I said exactly the opposite. And that's the way you win these cases. So you really need good records. You need good guest cards because testers are almost always failing to rent discriminations or discriminations of race. And the way a tester works is a tester will come in for race. One person will come in and say, I'm looking for a 1-bedroom unit. I'm looking to move in on, at the end of next month. And what do you have available? And you're going to show him 3 units, 2 units that you have available right now, and 1 unit that has given notice, but hasn't moved out yet. But he's not looking to move in until the end of next month. So you've got possibly 3 available units. You tell him about all 3. Another person comes in later on that same day and says, I'm looking for a 1-bedroom apartment. I want to move in immediately. That person, you only tell about 2 units because they want to move in immediately. You've only got 2 empty units. You don't tell them about the unit that is on notice because they haven't moved out. It's not available. It doesn't fit their qualifications. But if those 2 people are testers, you're going to get a discrimination complaint on the grounds that one person came in and you told them about 3 units, another person came in and you only told them about 2 units. That is disparate treatment. You're treating 2 people differently. And that is going to get you a discrimination complaint with the tester. With the guest cards, because these are not tenants, if you can go back and look at a guest card, you can see that one of them said, looking to move in at the end of next month, one of them looking to move in immediately. Then you have a defense as to why you treated them differently. So look for things like that. But you only have that defense if you make the notations on the guest cards. So make notations on guest cards, make notations on maintenance requests. I get a lot of discrimination complaints about maintenance requests, and one of them is my maintenance always takes longer. Okay, we look at all the maintenance requests. Most of them, in my experience, you fix within 2 or 3 days, always within the statutory time frame. However, one of them did take longer. But you look at the information on there, and it's usually, this is what happened. Tenant makes a maintenance request, does not give permission to enter, is not available, and you have to schedule an appointment. So the first appointment that you can get scheduled with the tenant is 4 days out. You go 4 days at the time of the appointment, the tenant is not there. You then leave a note, tell the tenant he has got to remake an appointment. So 3 more days pass before you get a new appointment. You go in, you figure out what's going on. It's a part that you have to order because you don't have it in stock. You order it. The company tells you it's going to be 10 days because of the shortages out there. And so you come back and you tell the tenant, we've got to order it. At the end of the 10 days, you get it in. Again, you don't have permission to enter. You have to schedule the appointment. The tenant's not there. You reschedule the appointment. Finally, 34 days later, you fix whatever it is. And the tenant, and you get a discrimination complaint because the tenant says, my maintenance is taking too long because of my race or my disability or something like that. If you have those things noted on a guest card or in an email to a tenant, this is why things are taking longer. That's your defense. If you don't note those things, then we have to try to refigure out why this one took longer. And the general rule in lawsuits and litigation is if it's not in writing, it did not occur. So you may have had 10 conversations with the tenant about what's going on, but by the time you get to a discrimination complaint, they're going to allege that none of that ever happened. So that's why you need to do things in writing. You need the records to indicate why you're doing this. The other thing that testers do is they will make claims for different rent amounts. So if one person comes in and says, I'm looking for a 1-bedroom for a 6-month lease, and the other one comes in and says, I'm looking for a 1-bedroom for a 12-month lease, and you quote different rent amounts for the same unit, again, you're going to get a discrimination complaint if they're testers. But the way you defeat it is you make a note on the guest card. Again, one was looking for a 6-month, one was looking for a 12-month, and you can show at that time we were offering 12-month rents at this rate for those units, whereas for 6 months they were a higher rate. So really, written records are your friends. Absolutely keep them. Number 2, the other takeaway, don't answer hypothetical questions. Hypothetical questions are almost always testers. And let me give you an example. So a person calls you on the phone and says, I'm looking for an apartment. You talk about the apartment and they say, if I were to move in, could I get a free reserved parking space? And you say, no, reserved parking spaces are all $50. That's your policy. However, it is possible under the law to get a free reserved parking space. Tenant makes a reasonable accommodation. They have a mobility defense. They give you a medical letter, or the defense is obvious. It is possible to get one. But with a tester, when they ask you that question, even though the issue of disability never came up in the conversation, you said, no, you can't have one. You're going to get a discrimination complaint for failing to accommodate their disability. Now, remember, with a tester, this discrimination complaint is going to be based on a phone call that lasted 12 minutes that you had 11 months ago with a non-tenant. Without records, you're never going to remember what that conversation was. But the whole time during that conversation, the tester is sitting there taking notes. They can't record it because that's a felony. But they can sit there and take notes. They wait 11 months and then they file the discrimination complaint and they base it on their notes. You have no notes because why would you take notes on something like that? It was a one-off phone call, but you told them, no, you cannot get a reserved parking space for free. So that's a hypothetical question. The answer to that is, I can't answer your question without looking at some documents and knowing more information. Why don't we make an appointment for you to come in? You can tour the property, look at the units. You can bring this medical information with you, and then I can tell you yes or no whether you would be eligible for it. You never said, no, you can't. You invited them into the unit or into the property for a tour, things like that. You don't get a discrimination because they cannot say you told them no. So find a way to not answer hypothetical questions. The other thing that comes up a lot in discrimination complaints is what is called the interactive process. And this is almost always reasonable accommodation or modifications. A reasonable accommodation is a change in your policies to accommodate a person with disabilities. A reasonable modification is a change in the structure of the unit to accommodate a disability. The interactive process is when somebody makes one of those requests, you are required to either grant it or engage in the interactive process. If you grant it, you're fine. If you don't grant it, if you simply say, no, we won't do that, period, you're going to get a discrimination complaint, and you're going to lose that discrimination complaint for failing to engage in the interactive process. That is the back and forth to find an alternative solution because you can't grant what they're asking for. So you've got to do that. The question becomes, how much do you have to do that? The more that you do, the better off that you are. Okay, so a question just popped up. Can we get examples of hypothetical questions testers may ask? The one that comes up all the time is the parking one. Can I get a free parking space if I were to move in here? And that's the one I see most often in discriminations. So that was the example that I gave you is just don't say no, say, they're all $50. That's when you say, well, maybe, but we need some more information. So those are the types of hypothetical questions that you will get. Okay, so let me tell you the horror story of the interactive process. We had a discrimination complaint that the woman, this was a townhouse, and you may be familiar with some of these townhouses where they have a garage and they have a very short driveway. I'm talking 5 feet of a driveway. And then there's the sidewalk, and then there's the street. This woman wanted to park a pickup truck not in the garage, but in front of the garage in the driveway as a reasonable accommodation, because she said she was disabled and was not able to get out of the pickup truck if it was parked in the garage. What it really turned out was she didn't want to park the truck in the garage because there was no space in the garage, even though the rules say you have to use the garage solely for parking. You can't use it for storage. She admitted she had a 5-bedroom house worth of stuff stored in that garage. So she said, well, I want to park in the driveway. We told her, no, you can't park in the driveway, because if you do, we've measured your truck, and your truck, even if you nose it right up to the closed garage door, your truck is going to cover the driveway, cross the sidewalk, block it, and it will stick out 6.5 feet into the street, and no traffic can get through. So you can't park in the driveway. We then went back and forth saying, we have other places that you can park instead of in the driveway. We just need to know what will work for you. And every time we did that, the response we got from her was, I don't know. I don't know where I can park. I just want to park in the driveway. And we kept saying, well, you can't park in the driveway. Here's why. But let us know. We have this place and this place and this place. Which of these will work best for you? I don't know. I just want to park in the driveway. By the time the process ended and we got the discrimination complaint, we had made 17 other requests for information and offers of other places. And every single time her response was, I don't know. I just want to park in the driveway. And ultimately, we settled that case because ultimately we got an investigator who said, you didn't do enough to engage in the interactive process. And I pointed out the federal case that said a disabled person is the best person to be able to tell us what alternative would meet their disability. So we're offering things and we keep telling her in these emails, if you have another idea, please tell it to us. And we always got the same answer. So where is enough is enough? Where can we say we've done enough? We did another case where we did that same thing, and we ended up settling that one, and it became a parking issue. And we offered them like 16 different parking spaces. Didn't like any of them. All kinds of things. Meanwhile, he was gaming the system, and we've all had tenants like that. That nothing that you do will satisfy them. But if you don't do enough, and there is no hard and fast rule as to what is enough, you're going to get a claim of not engaging in the interactive process. And so you can be found to have discriminated solely because you didn't do enough to engage in the process. So make sure you don't just say no. You say no, but we can do no, here's why, and we can offer you A, B, C, or D. If you think any of the other reasons or other issues would meet your request better, please tell us what those are. Let's talk about this. Always put it back to them. Let's talk about this. I'm offering you these things. Tell me what will work best for you so that you can show that you have done as much as you can to engage in the interactive process. So be careful about that. It is becoming more and more common to see a discrimination complaint based almost entirely on failing to engage in the interactive process. So we've got about 7 minutes left. So that is the end of my slides. I now have a black screen. Are there any other questions or questions at all?
Randy, thank you for all of that information. This is an opportunity while you have Randy here to ask any questions you might have about this topic. And again, as a reminder, we will send this recording and a PDF version of these slides out to everyone who registered today. Amanda, thank you for being here. I'll just give a couple parting remarks. But again, if you think of a question, definitely throw that in the chat real quick so Randy can answer that for you. Give us till the end of the day to wrap this up and send out this recording and things to you. Thank you so much for attending. We encourage you. Oh, Brenna's got a question. What are the most common discriminatory lawsuits? That's funny. I asked Randy when he said, I have 60 open discrimination files sitting on my desk. I asked him that question, like, what is the predominant? So Randy, you want to address that?
Yeah, race is involved in, I would say, 70%. And disabilities. So race and disability account for probably 95% of all the discriminations out there. Okay, so another question popped up. Can dogs be discriminated against? Actually, no. And it's not silly. I get that question a lot. Animals have no discrimination rights. Companies have no discrimination rights. So if you have a separate set of rules for, let's say you have a property that has commercial spaces on the sidewalk level and then residential spaces above, you can have a completely different set of rules for the commercial spaces than you do for the residential spaces, because commercial spaces do not have any fair housing rights. Animals, you can't discriminate against animals. So I have had requests that say, My ESA is in the unit all by himself during the day while I go to work. He gets lonely, so he needs an ESA. And that's pretty easy. I just say no, can't have it. I don't ask for anything. That's a hard no. Your dog has no discrimination rights. So, okay. Next question. If your community offers open first come first served parking for free, would we be required to provide a reserved space as a reasonable accommodation? Yes, probably you would, because if you look at the way parking lots are structured, the open spaces are almost always out in the parking areas, not right up by the doors. Those almost always tend to be covered parking spaces, but also if the person has a mobility disability, even though there's free parking around the parking area, they may need a reserved spot right up by the door so that they can get into that door. So yes, I think you would still have to provide a free reserved space for them as an accommodation. We have 3 to 4 ADA spaces outside all of our buildings. That's good. However, anybody who has a placard or tag can park in those spaces. So what you're going to run into when somebody makes that request is, and your response is, do you want to just park in the ADA spaces, or do you want a reserved space? And almost always they're going to say, I need a handicap space. And they will park in those handicap spaces and they will be happy until they come home from work one day and somebody is parked in their space. It's not their space, but they treat it as their space. At that point, they're going to say, I need a space reserved for me. So offer them both, but know that you're probably going to have to change it at some point when they claim that other people are parking, or they tell you, I want you to tow this person out of the handicap space who has a handicap placard because it's my space. It is not their space. You can't reserve a handicap space. So
Kenzie's got a really
great of those conflicts.
Yeah, Kenzie's got a great question about charging for reserve
somebody
space.
Needs an ADA space in the garage. Can we charge to reserve the ADA space? Okay, so this comes down to what you're charging for. If you're charging for the space, no, you can't, because those have to be given for free as a reasonable accommodation. But if you're charging for garage access, everybody who parks in the garage, whether it's a reserved space or an open space in the garage, has to pay a garage access fee. Then yes, you can charge that because they're choosing to park in the garage. So you may want to change your lease to where you have a charge for reserved spaces, but you also have a charge for garage access. And that way you could capture those people who are parking either in the ADA space or in a reasonable accommodation space in the garage with the garage access fee. But you can't charge them a fee for a reserved space in the garage just because it's a reserved space.
Okay, well, thank you so much, Randy. I encourage all of you to just make sure you're following us on our website, LinkedIn, Facebook, Instagram. That's where you can find out about any of our upcoming classes. I do want to give you just a plug for our online education conference coming up in October. It's called Apt Connect. For one low price, you can attend. I think we have 16 sessions happening that week. They're just little 1-hour sessions, everything from maintenance and service teams to sales, leasing, and marketing to leadership and professional development. Lots of great content, including some legal content from our Director of Government Affairs, Brett Waller. So check that out. That's available on our website. Randy, again, thank you so much for everything you do for us. We appreciate you, and enjoy your Friday and have a great weekend, everyone.
All right. Thank you, everybody.